How to invite a judge to take over a case and dismiss a strict liability crime under California Penal Code 1385. Hey, how you doing? This is Alex Zouzlas, author of the book Courtroom Confidential. Today I'm going to discuss how to invite a judge to take over a case and dismiss a strict liability crime under California Penal Code 1385. Just a reminder, I'm not giving legal advice. I'm simply analyzing a situation which can occur. In this case, California trying to force an innocent property owner to plead to a crime they had no idea was being committed, and speculating how the situation can be addressed by a smart lawyer. The question is, under California Penal Code 1385, can you get a judge to dismiss a minor strict liability offense by inviting the judge to do so? As I'll explain in this video, the answer is an emphatic yes. I'll be talking a lot about a 2024 decision of the California Supreme Court, Wheeler versus Appellate Division of the Superior Court of Los Angeles County, which directly impacts this issue. I also want to emphasize that although a lawyer in this situation would be filing a pleading titled Motion to Dismiss, the lawyer is not filing a formal motion. Rather, the pleading is an informal invitation to the judge to exercise her or his inherent authority to dismiss a charge in furtherance of justice under PC 1385. As you'll see in my discussion of Wheeler, the request focuses on the equities of the case. So let's talk about the facts of a case I recently handled. In the case I worked on, the defendant, whom I'll refer to as K, was an officer in a company, Hazy, that owned a property in LA which it leased to another company, Smog. These are fictitious names. K was an officer of Hazy, as I just mentioned, but he wasn't an officer of Smog. In fact, he had nothing to do with Smog. As I'll discuss, this fact is critical to getting a judge to order a dismissal under Section 1385. Smog decided it was going to run an illegal cannabis dispensary on the property, at least from Hazy. No one with Hazy, including K, knew anything about Smog's dispensary. Also, California's implied covenant of quiet enjoyment prohibited Hazy from even going on the property it leased to Smog. So, other than one of Smog's cannabis customers stumbling into Hazy's offices with an empty bag of chips on his head and rambling about what was going on at Smog, there was no reason for Kay or anyone else at Hazy to know about Smog's cannabis dispensary. The cops found out about it, though, and when they did, they busted Smog. Not satisfied with charging the people who were actually doing something illegal, the prosecution also charged the person who had nothing to do with Smog, Kay. How could they do that? They argued that Los Angeles Municipal Code 104.15, the crime they charged Kay with, was a strict liability offense. So what's a strict liability offense? In its simplest form, a strict liability offense is a crime where the prosecution doesn't have to prove intent to commit the crime. In other words, an act, or in some instances, a failure to act alone is the crime. Since the prosecution doesn't have to prove the client intended to commit a crime, a lack of intent or an absence of guilty knowledge are not defenses. If the prosecution proves you did something, that's pretty much it. Probably the clearest example of a strict liability offense is Florida Statute Section 800.04, which makes it a second-degree felony to engage in certain type of activity with a person who's older than 12 but younger than 16. The statute specifically prohibits the defenses of consent, lack of chastity, the accused's ignorance of the complaining witness's age, the accused's bona fide belief that the complaining witness wasn't under the age of 16, or the complaining witness's misrepresentation of her or his age. Basically, if your client had relations with someone under 16 who looked like an adult, told your client they were an adult, even showed your client a fake driver's license saying they were an adult, your client's guilty. So the prosecution in Kay's case contended that because LAMC 104.15 was a strict liability offense, Kay didn't have any defense to it. They offered Kay a sweetheart deal, but Kay was senior management and one of Hazy's board members, possibly with aspirations to work in similar capacities with another company in the future. So pleading to any crime, no matter how minor, could have led to his being fired and removed as a board member of Hazy, as well as it could have put the kibosh on future employment plans. So let's take a look at LA Municipal Code 104.15. In relevant part, subsections A2 and 3 say it's unlawful to rent or lease property to anyone, that includes a person or a company, that conducts unlicensed cannabis activity on the property. Though the prosecution didn't explicitly say so, it's reasonable to believe that they were saying section 104.15 is a strict liability offense because the words intent, intend, or intended aren't used anywhere in the language of the code. Though it's arguable that section 104.15 isn't a strict liability offense because it also doesn't say that lack of intent is not a defense, let's assume that 104.15 is a strict liability offense, especially since the Supreme Court's decision in Wheeler discussed section 104.15 as a strict liability offense. Like Kay's case, the defendant in Wheeler, Mrs. Wheeler, owned property that she leased to a company that ran an unlicensed cannabis dispensary. Mrs. Wheeler didn't know about the dispensary. She didn't have any reason to know about it. And other than renting the property, she didn't have anything to do with the company she rented the property to. She was charged with violating section 104.15 for no reason other than her renting the property to the company that was running an unlicensed cannabis dispensary on it. Mrs. Wheeler filed a motion to dismiss the charge against her under Penal Code Section 1385. She argued that she couldn't be held responsible for her tenancy legal activity since she didn't have any knowledge of it. The trial court denied the motion, as did the Court of Appeal, reasoning that since 104.15 was a strict liability crime, Mrs. Wheeler's lack of knowledge was irrelevant. The California Supreme Court disagreed. It held that the trial court should have dismissed the case under Section 1385 because of the equities of the case. Mrs. Wheeler lacked any knowledge of the tenant's criminal activity. She didn't have any contact with and didn't have anything to do with running the illegal dispensary. She didn't have a criminal record. Her culpability was minimal, and the charge was a very minor offense. The Supreme Court observed that Section A of PC 1385 authorizes a trial judge to dismiss a case in furtherance of justice. The statute allows the court to take charge of the prosecution and dismiss the case on its own. In other words, the judge can take over the case to do the right thing when the prosecutor won't. A Section 1385 invitation for a judge to dismiss a case doesn't even have to involve a consideration of the merits. Many times, the court in Wheeler noted, courts are invited to order 1385 dismissals even where the indictment is valid and the person has already been convicted. Since the trial court is being asked to do the right thing in the furtherance of justice, it's the equities that are paramount. So what are those equities? Here's a list of the equities that justify dismissal under Section 1385, which I'll be discussing in more detail. Low level of culpability, no knowledge, no reason to know, no involvement with the company running the unlicensed dispensary, no criminal record, though a court can order dismissal in furtherance of justice even if the defendant who meets the other criteria has a criminal record. In a 1385 dismissal, a defendant's level of culpability is relevant. Indeed, the court in Wheeler wrote, modern penal law is founded on moral culpability because the collective conscience doesn't allow punishment where it can't impose blame. Since culpability, or the lack of it, plays a role in 1385 dismissals, in practice, a court can consider evidence of the low level of guilt or the low level of the nature of the offense, even though the charge is a strict liability crime. In Mrs. Wheeler's case, the Supreme Court found because Municipal Code 104.15a permitted non-criminal treatment of the least culpable violators, a dismissal under Section 1385 that references a defendant's minimal bottom of the spectrum culpability as one of the dismissal considerations serves the ends of justice. The Supreme Court in Wheeler rejected the appellate division's conclusion that the trial court should not have considered the defendant's lack of knowledge because she was accused of a strict liability offense, holding instead that Section 1385 is not limited by the fact that Section 104.15 imposes strict liability. In the end, the court held that the trial court had the discretion to consider the technical and very minor nature of the alleged violation, as well as other equities, including Mrs. Wheeler's lack of knowledge and her clean record. The upshot of Wheeler, then, is that a judge has the inherent authority to dismiss a case against a property owner who's charged with renting property to a tenant that runs an unlicensed cannabis dispensary if the property owner didn't know what was going on, had no reason to know, didn't have anything to do with the company running the dispensary, and didn't have a criminal record. I would add the following additional points that a smart lawyer should be aware of in making a 1385 motion to dismiss. First, dismissal under Section 1385 is not an argument that has to be made in a demurrer. Second, it isn't necessary to affirmatively show prejudice for a 1385 dismissal. Third, you're not arguing that Section 1385 offers immunity from prosecution. Fourth, violating a tenant's implied covenant to quiet enjoyment or violating LAMC 104.15 is an impermissible Hobson's choice. Fifth, the substance of a motion controls over its title, so that even if your pleading is titled Motion to Dismiss under Section 1385, the pleading isn't a formal motion. Instead, it's an invitation simply for the judge to exercise her or his inherent authority to dismiss the charge in furtherance of justice. And sixth, where the prosecution doesn't or can't dispute the accused's lack of knowledge, lack of involvement in the tenant's illegal business, lack of a criminal record, and minimal culpability, a lawyer does not have to offer affirmative evidence in support of the 1385 motion. Now I'm going to move to an alternative theory of strict liability that the prosecution may make in a Section 104.15 case. The theory that strict liability arises under the responsible corporate officer doctrine. The RCOD has its roots in the U.S. Supreme Court's decisions in United States versus Dodderwijk, found at 320 U.S. 277, 1943 decision, and United States versus Park. The citation is 421 U.S. 658. That's a 1975 decision, which addressed violations of the Federal Food, Drug, and Cosmetic Act. In both cases, the statutes with which the defendants were charged under did not have a mens rea requirement and imposed only misdemeanor penalties. In Dodderwijk, the president and general manager of a pharmaceutical packaging company had been convicted, along with his company, for misdemeanor violations of the FDCA involving the shipment of misbranded drugs in interstate commerce. On appeal of his conviction, Dodderwijk, who supervised the day-to-day operations of the company, argued that he could not be held personally liable for the violations because only the corporation was a person subject to prosecution within the meaning of the statute. The United States Supreme Court disagreed, ruling that the statutory term person includes both corporations and individuals even if the individual inside the corporation doesn't have any knowledge of the wrongdoing. Although the court acknowledged the inequity of penalizing an officer who didn't know about the wrongdoing, it concluded this was okay because it was the result of a legislative balancing of hardships. Congress felt that the health risks to innocent customers outweighed any hardship suffered by corporate officers who might not have intended to violate the statute, but who, nevertheless, stood in a position of responsibility to the harm and had a chance to find out about the potentially dangerous conditions before the company engaged in the illegal commerce. Over 30 years later, the Supreme Court reaffirmed and clarified Dodderweich in United States versus Park. Park, the president of a national food store chain, had been convicted under the FDCA for causing the contamination of food held for sale following its shipment in interstate commerce by allowing it to be stored in a rodent-infested warehouse. That's disgusting. On appeal, Park argued that he couldn't be held criminally liable for the FDCA violation because he had delegated responsibility for warehouse sanitation to, quote, dependable subordinates, and therefore he wasn't personally involved in the wrongful conduct. You can probably see that the dependable subordinates weren't so dependable and that this argument wasn't going to go anywhere. And it didn't. The Supreme Court rejected Park's argument, holding that the government didn't have to prove that Park had committed a wrongful action because the criminal liability of corporate officers under the FDCA doesn't turn on an officer's awareness of some wrongdoing or conscious fraud. The government establishes a prima facie case when it introduces evidence that the defendant had, by reason of his position in the corporation, responsibility and authority either to prevent or promptly correct the violation, and that he failed to do so. The court explained that corporate officers have a duty to implement measures to ensure that violations don't occur in the first place, and they also have a duty to seek out and remedy violations when they occur. In Dodderweich and Park, the Supreme Court established the principle that corporate officials with authority and responsibility for supervising subordinates may be held criminally liable without showing that the officer knew the violations, where the statute violated contains no mens rea requirement and carries only misdemeanor penalties. This principle has become known as the RCO doctrine, Responsible Corporate Officer Doctrine. There's one huge difference in the facts of Wheeler and Kay from those in Dodderweich and Park, and that factual distinction makes the RCOD inapplicable to cases like Wheeler and Kay. In Dodderweich and Park, the illegal activity was occurring in the companies that Dodderweich and Park were corporate officers of, while Mrs. Wheeler and Kay had nothing to do with the companies that were running unlicensed cannabis dispensaries. That's a distinction a smart lawyer will have to make when the prosecution tries to hold the defendant strictly liable for a misdemeanor offense under the RCOD. Last, I should mention that the trial court ended up dismissing Kay's case based on the 1385 argument I made in the motion I drafted for the attorney of record. Those are my thoughts on this very interesting subject. Please post any comments you have. They always generate interesting discussions. Subscribe to my channel, and if you're a lawyer, consider hiring me to research legal issues and draft pleadings under your supervision. My contact information is below. Thanks for watching, and I'll see you next time.